All right. So we are here. We are recording. Chad, how are you, sir?
I'm doing good, Justin. How's your Monday or Tuesday now going?
Tuesday is busy. It's the beginning of the month. We got a new set of homeowners that are, unfortunately in foreclosure, and so we're trying to serve them and see who needs our help. But for the audience, for the people that do not know you, if you can introduce yourself, let them know who you are and what you do in the areas that you serve.
My name is Joseph Chad Brannen. I'm a lawyer here in Morrow, Georgia. I've been practicing law since 1995. I have both a bankruptcy practice and a probate practice, whereby in bankruptcy, I represent people filing bankruptcy, and in probate, I generally get appointed as a county administrator, uh, both in Fulton and Clayton County, uh, and help manage estates for either unrepresented estates or estates where the heirs are not in agreement on how to proceed in the estate process. In bankruptcy, I'm generally filing Chapter 7 and Chapter 13 cases for parties who need some type of bankruptcy protection to protect an asset like a home, land, car, or wages from garnishment or other collection activities.
Okay. Now, when you say county administrator, what exactly does a county administrator do? You said Fulton and Clayton.
Correct. A county administrator is an individual, typically a lawyer. They don't have to be a lawyer. They could have some other skill set that allows them to be the administrator. But an administrator is appointed when the probate court either one recognizes that the estate has heirs who are, one, not able to be identified, or two, not able to agree upon who shall serve as the administrator if there is no will, or even two, if there is a will that's been presented to the court and the heirs are trying to contest who is the named or nominated executor in the will. So uh, they're similar functions, but with different titles in the estate process. But generally speaking, it's because the heirs can't chart a common course to see a case, an estate to completion.
Okay, that makes sense. So, how often are you seeing that happen? Is that something that's every single month, like more than people would imagine, or
It's probably way more than anyone would imagine. Even a county like Clayton, which is relatively small geographically in relation to other metro Atlanta counties, keeps us busy. There's probably three or four county administrators that could be appointed in cases, and it's it's more than 5 to 10 a month. I mean, it's a pretty good volume that we get involved in.
and then with these 5 to 10 a month, are most of them, do they have like real estate attached, or is it like a multitude of things, like where it's stock
I'd say
accounts, all kind of stuff?
I'd say 90% of the cases that I get involved with involve real estate. And
Okay.
the majority of those are, it was the home of the decedent. So it's factually, I come across this fact pattern more frequently than not. Mom and dad have both passed, and once the last one dies, there's a house that needs to go to one or more heirs who are generally the children of the deceased, and the children are fighting on how that house is to be handled, the contents, how are they to be handled, and you can just see some sort of vicious activity between family members when we're fighting over what they believe is should be rightfully theirs versus what should be legally theirs.
So I guess, how does it get determined when the county administrator has to step in? Like, does the probate court, someone files, right? They say, "Hey, I want to be the administrator or the executor of my deceased loved one's estate," right? They go through the process, they file a petition to be the administrator. At what point does the court say, "Hey, you know, you and the heirs are not getting along. You're not on the same page. And so we're going to have our county administrator step in."
Usually, after a petition is filed, notice goes out to all the interested parties. If an interested party files an objection and that objection remains, or caveat as they call it, remains unresolved, the court will have a hearing. And if the court determines that at that hearing that there's just too much negative press going on between the two heirs or multiple heirs, that they'll appoint a county administrator. It's oftentimes triggered with one of the heirs saying, throwing up their hands and saying, I don't want to do this. Let's appoint a county administrator. And the courts would generally default to appointing a county administrator because, if there's a heated dispute, just because one of them gets appointed as the administrator doesn't necessarily tone down the temperature between the parties. So the courts kind of have come to recognize that, well, if we appoint one, we're going to have the same fight later, because they're not going to be happy with one another. So county administrator, a neutral party, is appointed, and that generally calms the temperature down enough where you can proceed with how do you handle the estate.
Okay. And I would imagine as a county administrator, you're making decisions based off what's best for the estate. You're not making decisions based off of emotions or anything like that.
Correct. Most of these county administrator cases involve no will for the decedent, which means you have to follow Georgia law in reference to intestate succession. If someone dies, there's a certain flow chart you follow that says these people are the parties who will be entitled to receive from the estate, and you have to follow those rules. And that generally sort of diffuses some of the problems, but you still got situations where, again, one of the more common circumstances is after the last parent dies, there always seems to be one of the children or multiple children who moved in back into the home with the parent before they died, and they say they took care of their parent, so they should get more of the estate than the child who lived in another state and didn't see their mom and dad as much. So that's a very common scenario that we deal with in probate court. And unfortunately, or fortunately, depending on whichever way you look at it, the law is pretty definite in how it sets forth the heirs. And just because one heir lived with their parents when they died doesn't give them a right to more than the child who was living in California, living their own life.
Gotcha. Is there like a certain timeline as to when, like, okay, an heir's file probate, heir's not getting along, county administrator steps in? Is that typically like 2 months in, 3 months in?
It depends on the circumstances. I know probably when you are coming across these in your business, you're coming across a property that's in some sort of stressed situation, whether it's a mortgage not being paid, a home in disrepair, several items that can come into play. And what I generally do is when I get appointed, I check to see if there's real estate involved. If there's real estate involved, try to find out who's living there. And sometimes I get calls from investors saying, hey, I understand you are the county administrator in this estate. We have interest in this home. So I start my investigation to find out who's in the property, what's the status of the property, determine if there's a mortgage, if it's paid or not, and then try to alert the heirs to the next step, which means we either, one, need to get this property sold so it doesn't suffer any more stress financially or physically to the structure, or if one of them wants to buy out the other heirs, to put an offer on the table so we can figure out if that's the route we're going to take.
Gotcha. You mentioned buy out the heirs, right?
Yes.
Something that we've actually been looking into is buying out the heir's interest in an estate while it's going through the probate process, right? Is that something that can legally be done?
Yes, I think you would need to seek court permission. I see not a lot, but a number of instances where an heir who is not the legally authorized representative of the estate enters into a sales contract to sell a home. One, that contract is really not legally enforceable because the legal party isn't executing it. And then two, that one heir who's looking to sell may already have taken money from the investor as sort of a down payment or a buyout of their interest that they will receive from the home. So it just creates a cumbersome process when you handle it that way. The cleanest way to do it is to surely file what's called a petition for leave to sell, which is a pleading in the probate court where you seek permission from the court. court sends out notice to the interested parties and will either grant the petition and the administrator can sell it, or it could deny it if there is objection. There's usually not a lot of objections filed to petitions for leave to sell, but that's the proper way to do it. Anytime you have sort of a renegade heir trying to sell something they don't have a legal right to, you clearly run into violations of probate law, but then you also run into title issues. If someone's just trying to sell something they don't have a legal right to sell, you're not selling something that's legally enforceable.
Got you. So with petition for someone calling me for petition for leave to sell, that is where the probate court allows the estate to sell the real estate before probate is done, correct?
Yeah, and not to sort of confuse words. Most people think of probate as uh, the, the the whole process just upon filing it, but the probate is really from the initiation of the probate case until the discharge and closing of the estate, and obviously from beginning to end could last anywhere from 6 months to 5 or more years, depending on the complexity of the case. But in a in an estate where property needs to be sold, you file the petition, get an order from the court, you then sell the property. The net proceeds from the closing will then be paid to the estate, which will be held until disbursements are made to the heirs, either pursuant to intestate law or upon agreement of the heirs. But you can generally, from filing a petition for leave to sell, particularly if you file it as an emergency because the house is either in a distress situation, either behind on the mortgage and facing foreclosure, or behind on taxes and facing a property tax sale, you can generally get a emergency petition granted anywhere from 30 to 45 to 60 days.
Okay, that was actually my next question is like, what's the timeline of getting that done? I guess what would stop a petition for leave to sell? Like, what would make the judge say, "Hey, I'm not approving this"?
I think one, the sales price. If you're trying to get the court to approve a sales price that's less than perhaps the true fair market value, and generally in these petitions you submit a copy of the tax assessment from the county to sort of give you some baseline of what value of the home may be. Uh, I've had some heirs object to the sales price, but if I've even had cases where we had a hearing on a petition for leave to sell and the heirs objected to the sales price, but upon hearing all the evidence and hearing from the potential real estate agent, if there is one, or the investor who may be buying it, the condition of the property is actually less than what fair market value would be if it was a home in good condition. So I think factors such as the condition of the property, the status of any mortgage delinquency, if there is a mortgage delinquency, and perhaps how long the estate's been pending are some factors the court generally utilizes. But just from a practical standpoint, if I'm selling a home without other independent concerns, you know, generally it's being sold by a real estate agent, so we're putting it on the market and trying to get the best price we can for it. On the flip side, where it's an investor kind of transaction, I try to submit some accompanying documentation for the court to review to understand why we're trying to sell it for the price we're selling it.
So documentation would be like pictures, video, evidence that, hey, this is why the price is the price. It needs this amount of work.
Yeah, and sometimes what I call it, the online data points, Zillow, tax assessment, other such resources can be skewed because this is a property that's on a county line and it's getting sort of tagged with brand new homes that are being
Yeah.
built 1 mile down the road that may be in a different county or municipality, and that sort of skews the online data points.
Yeah, 100%. And I'd imagine the judge doesn't give two craps if it's an investor and they're like, hey, I've got holding costs, rehab costs, realtor costs, closing costs, all of that stuff. They're looking at what the actual fair market value is.
Yeah, I think what the court is trying to do is to get the best price they can under the circumstances for the asset to maximize the distribution to the heirs.
Gotcha. Makes sense. Okay. What would you say is the most common mistakes that heirs make whenever they are filing for probate?
Mm,
More particularly, the heirs that are facing foreclosure.
uh, Not identifying all the heirs. I think that's a common thing I see, particularly with blended families. It's not uncommon that someone may have had children with one spouse and then had subsequently had children with a different spouse, and that's one common concern, particularly when they're not represented by a lawyer and they filing as we call pro se on their own. That's one of the things I see that's glaring that can slow down the process because courts legally charged with notifying all the heirs at law if there's no will, uh, and that can be a large number of people if it's a big family and, like I said, marriages and remarriages. Uh, if a heir at law has deceased, you got to notify their heirs at law, so that continuing right to receive can be alerted to that party. Commonly, it's a grandchild, because their parent may have uh, predeceased their parent, and so the grandchild stands in their parent's shoes and has legal right to be notified. And sometimes those grandchildren are minors, and minors create a different requirement for notice and representation. So those are some of the things I see that can impact sort of how smooth a petition can go based upon the petitioner's inability to get everybody properly notified.
Okay. If an heir is facing foreclosure, and let's say, they just found out about their loved one's real estate being in foreclosure and we're 3 weeks out from the auction, what is like the best steps for them to take to get the foreclosure postponed so that way they can start the probate process and hopefully save the real estate?
Well, I'm going to answer that from both information I've sort of garnered during the years being a bankruptcy lawyer and more recently as a probate lawyer. Uh, I have seen cases where an heir at law who had no legal authority, such as via letters of administration or temporary letters of administration, call the mortgage company and say, "Hey, my mom and dad has died. I've just realized they had a mortgage. It's 4 months behind. You're trying to foreclose. Would you be willing to postpone this foreclosure to give me time to get the probate documents filed, to get a person appointed to represent the estate, and then we'll be able to uh, you know process this, perhaps get you paid or get the home sold to get you paid, rather than losing the home and the equity at a foreclosure." Uh, I've seen that happen. I've seen that be unsuccessful as well. And the mortgage company say, "Well, you need to get a court appointed person in charge, such as an administrator or county administrator, so they can act on behalf of the estate." And I get a large number of those each year. I get appointed within days or a few weeks before the foreclosure. And in my bankruptcy practice, I've made contacts with many of the mortgage companies' attorneys who handle the foreclosures in Metro Atlanta, and I kind of give them an update, ask them to give us a temporary reprieve to see if we can't get this property sold. And for the most part, it's been accommodating. There's been a few where we've had to take some extra steps and be proactive, perhaps sue the mortgage company and the county court to the non-probate court to get a restraining order to stop the sale. So, those are some of the challenges you face as a county administrator when you get appointed in a case that has a property that's either facing foreclosure or foreclosure is imminent.
What do you do in situations like we dealt with a situation recently to where an heir didn't discover until 3 weeks before the auction date. This was actually in Clayton County. He didn't discover that there was real estate attached until 3 weeks before the auction date. He found out that Bank of America was a mortgage company. And when he contacted Bank of America was like, "Hey, until you are appointed as an executor or administrator and you have some type of probate documentation, we're not talking to you." What do you do in situations like that?
Well, I would encourage the heir to hire a lawyer or on their own get a petition for temporary letters of administration filed, because that's most efficient and quickest way to get someone appointed, even if it's on a temporary basis, you have the ability to act on behalf of the estate.
Got you.
Now,
Got you.
3 weeks is a fairly short period of time. I mean, in that scenario, probably the only thing you could do is to get the letters of administration, temporary letters in place, and then contact the law firm handling the sale to see if they would stop the sale on a consensual basis. Or you're probably destined to get into superior court in that county with trying to get an injunction or a restraining order, which is pretty challenging, and can be costly, but still an option. I've also had situations where an heir at law, after the mother or father, last surviving parent, has passed, they have a legal interest in that property, even if the probate process has not even been initiated or completed. I've had those family members file bankruptcy, particularly under Chapter 13 of the Bankruptcy Code. That ownership interest is enough of a link to the property to establish an automatic stay, so a person could file a bankruptcy and for a home that they don't technically own yet and protect it under Chapter 13. So those are a variety of things I've seen happen.
Got you. Got you. From a home buyer standpoint, investor standpoint, even maybe an agent standpoint, right? We get contacted by that heir and we know we're racing against time and we know we have to go through probate. What can we do from our standpoint to help save the foreclosure? Because from our standpoint, it's like, okay, we come in, we have a contract with the heir, right? We identify all the heirs and we have a contract with the person who's going to file to be the petitioner, whether it's admin or executor. And we file that with the court and we end up getting a reinstatement from the mortgage lender. And we're like, you know what we can do is we can reinstate the mortgage to get it out of foreclosure. But how does the investor or agent protect themselves so that way they don't get screwed on the back end if the heir just decides to go left and not work with them?
I think is a delicate position to take. If there's no probate process in place, or even more, if there's not an order from a probate judge sort of authorizing the estate to allow you to do that and to bind the estate to an obligation to repay you that money later if the house doesn't get sold to you under the terms of the proposed contract, the investor is really, I think, taking a risk in that scenario, because you're right. The investor could pay the $15,000, for example, to bring the mortgage current and have a proposed sales contract that's not enforceable because there's been no administrator appointed, or two, there has been an administrator appointed, but there's no order approving the sale, or there's no order approving the estate, again, allowing you to pay the money. You really could just be throwing money away, or two, have to become a creditor of the estate and get paid in the distribution from the administrator after the home is sold.
Hmm. So that, yeah, you got to be very careful. That's a big
Yeah,
risk.
it's about doing the paperwork properly. Now, I've had one of those. I've had one of those recently, but had been an estate that had been pending for a while, and I was able to seek permission from the court for the investor to come in, pay the arrears to bring the mortgage current, and if that investor ended up not buying the property, which they did, they ended up buying it, they would be able to get a claim against the estate and have their funds paid after the sale if a new buyer purchased it.
Makes sense. Makes
But you're
sense.
tying up your capital potentially in a
Yeah.
situation like that.
It seems like the safest way is to do what you mentioned, earlier, which is work with the bank on getting it postponed, file a petition for leave to sell, and go through that process. And once that is granted, if it's granted, then you proceed with purchasing the home. Yeah, that's okay. Um, have you ever seen a probate case go completely sideways because of title issues?
It's not uncommon. There are some challenges. I have not had an estate case where we could not sell a piece of property because of a title issue. Um, I've come into some cases where, a sort of common vernacular is that's heir property, which it's been owned by someone who's passed away many, many, many years ago, and title never got corrected or they never probated the estate. So at that point, you just sort of have to face the possibility that you may have more than one estate that you have to probate to get everything sorted out. Because, I mean, if a couple of generations have lived in the home and passed on and they no longer are living, and there's this grandchild or great grandchild who's wanting to sell this property, you may end up having to open several estates to clean title so the proper legal owner can participate in the leave to sell because there's multiple owners.
And at that point, you got to ask yourself, is it even worth dealing with?
Oh, yeah. I mean, that is certainly a practical consideration.
Do you have a lot of heirs who eventually just back out of stuff because, like, this is too stressful? I don't want to deal with it anymore?
Well, I don't say that when they back, I think there's two ways to define that. Backing out means they're just not going to be involved in the day to day activity of the estate. Rarely have I had someone renounce their rights under the estate and say, we don't want anything. Because why would they? I mean, they can have a county administrator handle it and they can just sit back and wait for whatever may come to them, whether it's 6 months later or 5 years later.
Yeah, 100%. Okay. Let's get into some bankruptcy. What is the most common reason that you're seeing people file bankruptcy right now?
For my practice, there are generally two types of cases filed: Chapter 7 bankruptcy and Chapter 13 bankruptcy. Chapter 7 bankruptcy is what most people commonly think of as a total bankruptcy, where you wipe out your debt and get a fresh start. There are obviously some considerations you've got to make in the Chapter 7 case, such as what are the person's assets, what's the person's debts, what's the person's income and expenses, because those are sort of some factors that go into determining whether you qualify or eligible for Chapter 7. Just saying, all things being equal, that a person is able to file Chapter 7 without losing any assets that they may own because they don't either have a lot or don't have a lot of equity. They meet the income requirements and such, and they have enough debt to justify filing a bankruptcy. Chapter 7 will generally eliminate debts like credit cards, medical bills. If you lived in an apartment complex and you broke the lease, if you had a car loan that you were paying for that you didn't finish paying on and it got repossessed and there's a deficiency, you may have co-signed with a family member or loved one on a car that they didn't pay and it's fallen in your lap because you were a co-signer. Those are similar circumstances that I see a lot in Chapter 7. Garnishments are also a big component of people who file Chapter 7 cases, but they're looking for a fresh start, get out from under the debt load, and begin anew from a credit and debt standpoint. Chapter 13 is more commonly used when someone is either about to lose their car from repossession because they got behind on it, or if they have a mortgage on a home they live in and they can't get caught up and they're facing foreclosure or too far behind to get caught up. I also have people come in needing to file Chapter 13 because they have an apartment that they're behind on about 4 months and they don't want to get kicked out, and they try to reorganize under Chapter 13. Now, the leases of apartments and such have a little more complexity sometimes, depending on the status of any eviction proceedings. But generally speaking, people file Chapter 13 to stop a car from being repossessed, stop a home from being foreclosed, and or otherwise can't do Chapter 7 and have to reorganize their debt.
Okay. So when a homeowner comes to you, right, and they're like, hey, my house is in foreclosure, I don't want to lose my house. And you tell them, hey, Chapter 13 is going to be your best option based on your circumstances and your financial situation, right? What typically happens to the mortgage? Because from our standpoint, being that our niche is helping homeowners who are in foreclosure and probate, a lot of what we see is we see a lot of homeowners that will file Chapter 13 bankruptcy, and 3 to 6 months later, they're back on the auction block, right? So what happens to the mortgage? And the other side of that is, what is a reason you see them back up for auction months later?
Probably the most common thing is the person who filed the Chapter 13 doesn't take advantage of the protection. Upon filing a case, unless you've had multiple cases in a fairly short period of time, when you file a case, either Chapter 7 or Chapter 13, an automatic stay goes into effect. Your creditors have to stop any and all collection efforts. That means they can't garnish your wages, they can't foreclose on a home, they can't take a car from repossession. They basically have to just stop everything they're doing to try to collect their debt. Now, in Chapter 13, it provides you a conduit to catch up the arrears or arrearage on the home through the Chapter 13 plan. And you have to also resume, in most cases, making ongoing mortgage payments so you don't get any further behind. So you see a good number of people file Chapter 13 and don't comply with their Chapter 13 plan. One, because they can't, because circumstances are just not allowing them to make complete the financial commitment to make the Chapter 13 work, or for lack of a better word, they filed the Chapter 13 just to stop the foreclosure and didn't have any intention on prosecuting the bankruptcy case. And at some point in time, that protection goes away, which would be probably in that 60 to 90 day window. If someone files a Chapter 13 and does nothing productive in the case, it's going to get dismissed. And then your mortgage company can go back to doing what they were doing before the bankruptcy was filed to begin with.
And now you just have less equity in the home. You essentially kick the can down the street. You stop the foreclosure, but now you owe more money to the mortgage company.
Well, you probably owe more money. The question of whether there's equity still or more equity or less equity depends probably on some market conditions more than the mortgage amount.
So I guess, is there like a certain percentage for the homeowners that do file Chapter 13 that you see back up on the auction block?
Chapter 13 can sometimes be challenging, both from the financial commitment and then just, people decide they want to do something different after they file. So a large percentage of Chapter 13 cases that get filed get dismissed in the early portion because either the person filing can't comply with the financial requirements or doesn't do anything at all in the bankruptcy case. I can't probably put an actual percentage on it, but a good number do. 25% or more, I'd say yes. There's a lot of people who get past that first hurdle and get their case under Chapter 13 confirmed, which is the approval by the court. But then something happens during the 3 to 5 years that it's going to take for them to pay off the case. They lose a job or other factors come into play, and it gets dismissed. Some people get past that first hurdle and can comply with everything they have to do for the full 3 to 5 years of their plan, and they come out the other end with a discharge. That's a fairly small percentage of people that get to the very end of their Chapter 13 plan and get a discharge, because it's a tough proposition.
When you say discharge, you're talking about the other debts, not the mortgage.
Yeah, and discharge of the case and discharge of the plan and the trustee. In most Chapter 13s, there will be remaining a mortgage debt because, again, the person who filed the Chapter 13 was only paying the arrearage through the bankruptcy. They were to resume and continue ongoing mortgage payments so they didn't get any further behind. So if they did everything they were supposed to during the Chapter 13, they would be fully current on the mortgage, and they would have reduced the mortgage because they paid it down with continuing mortgage payments for that 3 to 5 year period.
Okay, that's them sticking to the plan. And
correct. But that's a small number of people that go from the full filing to completion of a Chapter 13 case.
Gotcha. Okay.
People do refile as well. I mean, refiling Chapter 13s is not uncommon. I think the court probably has some understanding that if someone files a case, circumstances can happen in a good faith situation. They lose a job or have an illness or what. Refiling isn't shunned or harshly frowned upon, but someone who makes it a sort of an ongoing filing and refiling scenario can sometimes be faced with a circumstance that the court's not going to let them refile again, or the refiling is not going to give them the protection they need.
So is there a limit to how often you can refile? Because there's a lot of people we see, we call them repeat offenders, unfortunately. to where they
Well,
will file every time they're back up for auction. And we're just like, how are y'all able to keep refiling?
I am sure there are people that abuse the system. As a practitioner, we try to avoid those and try to sort those out. But there really is no bar like that is immediately there to say you cannot refile. There are some practical components of the bankruptcy code that says if you have been in a previous bankruptcy in the 12 months prior to filing the most current case, you may only have an automatic stay for 30 days unless you petition the court to give you a continuing automatic stay because there were legitimate factors that caused your prior case not to work. If you've had more than one case pending in the last 12 months and you file a Chapter 13 case, you don't have an automatic stay at all in effect. So you would have to petition the court to even what they call impose the stay because you filed and you didn't have an automatic stay in effect. Again, you see that with people who have filed 2 or more cases within a 1-year period or have had pending cases 2 or more within the 1 year prior to filing the most recent case.
Gotcha. What is the difference between a Chapter 7 and a Chapter 13?
Well, again, Chapter 7 is for people who are trying to basically get a fresh start, elimination of debt quickly, and move on with their life. They generally don't have homes. If they do, they don't have a lot of equity in their homes, and you don't see that a lot now. I mean, the dynamics of pre-COVID, post-COVID, you saw a lot of appreciation in value just for the sake of real estate just went up so much in value during that period of time that people, particularly for people who bought homes prior to 2023, they have seen their, maybe 2022, have seen their property increase pretty substantially since they acquired it. So I have a lot of clients who come in who might be interested in Chapter 7, but they have equity in their home, and that's, that's a case-by-case analysis. Certain factors like whether you're married or single, whether you have 1 mortgage or 2 mortgages, those are factors that you have to use to evaluate it. But Georgia has a somewhat limited homestead exemption, unlike some states like Florida that have a much larger homestead exemption.
Does income, the amount of money that they make, matter?
It does. In Chapter 7, you have to pass what's called a means test, which is a review of your previous 6 months of income to determine what your disposable monthly income is. Then there's a calculation that you analyze that to determine if you are required to be in a repayment plan or should be in a repayment plan versus Chapter 7. Then you also have to propose a budget with the court that shows what your actual income and expenses are. And if the court sees that there's a large amount of excess income or disposable income, they're going to say, no, you need to be in Chapter 13 or you need to repay your creditors rather than wiping them out under Chapter 7. Chapter 13, again, is a debt consolidation, reorganization of your debt, primarily consumer debt, over a period of 3 to 5 years.
Gotcha. Okay, makes sense. Is there ever a point where you might advise a homeowner, hey, I don't think filing bankruptcy is going to be in your best interest. I think maybe you should consider, start selling the property and starting a new chapter.
Yeah, I mean, people somewhat are naturally procrastinators. So in my bankruptcy practice, I generally have someone in front of me who's on the eve of something happening they don't want to happen. You're in a 60-day window of the home being possibly foreclosed, and that creates some challenges in selling the property. But the answer to your question is yes. I've had clients come in and say, I have this home, I've got a lot of equity in it, and I can't file Chapter 7 because if I do, I'll lose it. And they kind of go back and forth, and we discuss rational or reasonable efforts it would take to repay this debt over a period of time. And they look at me and they say, there are other options. I said, yes, sell your home and then cut deals with your creditors once you get your net sales proceeds and try to work it out that way. I've also had people come back and say, you know what, we'll file Chapter 7. We know we've got too much equity in our home, but we'll just take the homestead exemption we're entitled to. The trustee and the bankruptcy can sell our house and use any money they make after we're paid our exemption to satisfy our creditors. That's rare, but that does happen.
So a homeowner can sell their property if they're in bankruptcy, if they filed?
Well, the trustee would sell it on their behalf.
Got you.
A trustee is very similar to a county administrator in a
Yeah.
probate case, but they're doing it in a bankruptcy process.
Yep. That makes sense. Okay. Um, I mean, so you deal with families in crisis, all the time. Like, what's your advice to someone who like feels stuck, scared, and just doesn't know who to trust?
I think with matters involving assets and debt or other liabilities, speaking with a lawyer is probably the best advice I'd give anyone.
Yeah.
Uh, the Metro Atlanta has a good number of lawyers who work in the area. There are a lot of lawyers, particularly bankruptcy lawyers like I am, that offer somewhat of either a limited retainer or no cost retainer for an office visit. It can kind of tell you in 30 minutes or so kind of what you're facing and some potential steps you could take to resolve the problem. So getting good legal advice is always the best step.
100%. 100%. And from your legal seat, what kind of investor do you respect and what separates the good ones from the shady ones?
I've come across several parties who participate in the investor industry, and for the most part, there have been some good dealings. I think dealing with investors who understand the process is advantageous to someone who doesn't understand the process, because you could have an investor come in again who's not knowledgeable of the circumstances and just think there's a potential shorter cut or shortcut or more efficient way to get through this process, like making a deal with one of the heirs to buy out their interest and sell it on their behalf. You know, that may work once in a million times, but you're just setting yourself up for failure and disappointment and even perhaps loss of money. So to answer your question, I think it's just dealing with investors who understand the process. I think bankruptcy and probate are some things you probably encounter as an investor more so. I mean, yeah, you may be interested in a home that's the parties are going through a divorce, but yet at
Yeah.
some point in time, the divorce will be over. But I would say probably staying out of divorce is the best way to take that advice as an investor. But probate and bankruptcy, just understanding the process and having people you can call to rely on to give you the best legal advice and how you handle it from the investor or acquirer standpoint.
Agreed. Agreed. Well, listen, Chad, you have given some golden nuggets on this episode. Greatly, greatly appreciate you coming on here. If people want to get a hold of you, what is the best way to get in contact with you?
Yeah, I'm old school. Phone number at my office is good. I also have email. I think those are probably the two best ways to contact me. Get in with an appointment. I have a receptionist who loves to take calls and make appointments for people. So I can give my office number. Is that something you want me to do?
So this is what we're gonna do. So everybody that is watching this, if y'all want to get in contact with Chad and get a consultation on bankruptcy or probate, we're gonna drop a link in the description under this video, and you can click that link to get in touch with them. And that way, if you have any questions, like I said, you have that free consultation with them and get some advice, and hopefully Chad can help you out. Please, guys, if you guys got value out of this, please like, share, subscribe, comment. Let us know what else you want to hear. Let me know if you want Chad back on for another episode. I think he just gave some great advice. But I appreciate everyone tuning in. I'll see you on the next one.
Thanks, Justin. Take care, bud.
All right. Thank you.